So the only mics that work apparently are going to be up front.
All right, good morning, everyone. I'm going to call the recommending committee meeting, what is today? June 5th, to order, 2017. Are we in compliance with the open meeting law?
We are.
Whoopee. This meeting has been posted in various locations throughout the city. First item, let's see. Hold on. Bill number 2017-18 for possible action updates code provisions pertaining to the city's registration maintenance program for vacant properties that are subject to foreclosure and related proceedings. This is sponsored by Councilman Stephen Ross. Good morning.
Good morning. Code Enforcement Supervisor Vicki Ozuna. Back in 2011, the council approved an ordinance that adopted a foreclosure registry. That has been a very successful process of getting the mortgages to put on the registry information for code enforcement to utilize to contact them. But what we're seeing now in the last 4 or 5 years, the trend is, I'm sorry?
Are we talking about that? Oh, yeah, right, okay.
Okay.
We don't have a copy of that foreclosure registry, do we?
Yeah, in your book, isn't it?
Okay.
Okay.
So,
Everything is alive, so.
okay. So, over the last 4 or 5 years, what we've seen is an increase in our abatements, and most of the abatements that we are performing for code enforcement purposes on blighted neighborhoods, most of the abatements are, the houses are in a status of basically being abandoned. So, the banks are not putting them in default, which does not trigger them to require them to be on our registry. So what we would like to do is utilize the state's NRS 107 that has adopted an abandoned building definition and require them, change our registry from a foreclosure registry to a abandoned building registry, which basically means that if it meets the requirement or the definition of the state that it's an abandoned building, that it will need to be on our registration so that we have contact information from the mortgage company, anybody who has an interest in the property, to help us facilitate in getting these properties into voluntary compliance instead of the city having to do abatements.
If I might ask, whose responsibility is it to go around and find these vacant buildings? Do you have enough of a code enforcement group that you have enough can run around all over the city checking to see what buildings are abandoned?
Yeah, we certainly don't have enough staff to do that, but right now we react to people's complaints. We're not proactive in going out to find them, although in some areas, as we finish one abatement, the officers literally know which house the homeless people are going to move into next. But we do have a plan to move forward. We're starting up a data portal that is going to help us identify the probability that a house is abandoned and vacant. And then we're going to be performing a survey, hopefully in the next 6 months, and then we're going to come up with a plan on how much staff, if we need to increase staff, to go out and after we determine, which ones we need to address first and categorize them as far as need.
So your plan ultimately will be to vacate immediately anybody that's inside, put locks on doors and board up windows, etc.? Or at this point, no, the only thing you're doing is identifying?
We'll be identifying them, and then we'll be identifying the needs. So if there's no power, if they're open accessible, if they're causing a nuisance for the surrounding properties in the neighborhood, then we'll go through our process that we currently have, where we will notify all parties that are involved on the property, give them a chance to take care of it. If they fail to do that, then we will proceed with an abatement by contractor.
And has this gone through legal so that we ultimately are not assuming liability exposure by saying we're identifying that building and the city's now involved? Have you
Yes, this went through Val. Steve helped draft this. We're also we've taken this process. Henderson adopted, when all the entities were adopting their foreclosure vacant property processes, actually Henderson went a different direction and went with what the state had adopted, because by then the state had adopted in 2013 NRS 107. And they went ahead and adopted that process instead of going for the foreclosure requirement.
Okay. Mr. Steed, I know you're silenced over there, but you could use Councilman Anthony's. I don't think, oh, it does work. You're one of the gifted few. Look at that.
Something must be wrong.
Yeah. Is there anything to add to this as far as the exposure for the city? That would be of concern.
No, I don't think there's any undue exposure, anything more than we've already undertaken with the existing ordinance.
Okay, thank you. Yes, Councilman.
If I could ask, this is, I'm surprised we haven't made more progress in this over the last 5 years. It's just, when Councilman Ross brought this forward, I thought this was the greatest thing since sliced bread, because I was a new council member, but I was already recognizing the problem of the results of the Great Recession, and since then it's gotten worse and doubled and redoubled in its problems, where it is now a definite public safety problem. It truly is, because abandoned homes they're occupied by people that shouldn't be there, and several on my street are occupied in such a fashion periodically. So your staff and the other staff around on code, particularly in planning, I guess, I forget where else we've got people responsible, they're doing a good job of responding to complaints. We do get them, and the public is aware of the fact that our offices, respond, and so we do, but I just don't know how we can just go out and look for them, and we'll just have to continue to be reactive.
Well, and that's where our data portal project is going to be so important. It's going to have an intuitive programming into it to where it will help us identify the houses that are probably in a status that is going to lead to us to believe that somebody has walked away from it, and that it's probably in foreclosure, but the banks have not filed the required documents. We have a lot of properties that the banks do not want to recognize, because then they would have to put it on their bottom line. And quite honestly, they're in areas that they just don't feel that they care about. If it's something that happens in Ward 2, 4, or 6, we get very good compliance from the banks. And unfortunately, in areas 1, 5, and 3, they're not that responsive. And I think that's very unfair to the neighborhoods, and really, it's just another tool to help us
Well, Vicki, let me interrupt.
make them more responsible.
We thought that the banks would respond. And so for 5 years, we've been waiting for them to respond. They don't want to foreclose, do they? They don't want to officially foreclose,
No, they don't.
even though we told them they ought to. Are we at the point now where we have to put the bank's names in the print, that we have to associate them with this piece of property, put up a sign that said the paper on this bank, on this piece of property is being held by, Nevada State Bank or Bank of America?
I don't know that we could legally do that. Part of the other issue that code enforcement has is that the banks are selling these loans so rapidly, they don't even know what's in their inventory. And sometimes we can't, we do our best to identify who the mortgage holder should be, and they've already sold it off, and it's already 2 or 3 banks down the road, and they haven't recorded anything. So that's part of the detriment that we're working with, that we're trying to get past that. And I think also we would like to get ahead of the curve on the abandoned properties, which is why we want to go out and identify them and categorize them as to need of getting them secured, because I think if we can get ahead of that and get them secured, it's going to give the homeless or the transients less places to go, and they're going to have to finally maybe start moving to the direction that they need to for services. Not that I promise anything.
Well, they
like
loaned
but
that money out faster than they could keep track of,
and
and now they're not responding as fast as they should, because they're selling the loans faster than they can keep track of. That's crazy.
I
In
also...
the meantime, the neighborhoods are stuck with their profits.
Yes, and I also think that it's very important that, we do assess civil penalties in all these cases, and I realize that it's not the investors or the people down the road that are purchasing them, but it's very important that we hold the banks accountable on these properties. We I can say from the hearing officer process that he does his best to hold them accountable, and yet he does his best to also recognize when there's a neighborhood that's in desperate need to get a house occupied. So it's a fine line, but the banks are willing to go any route they have to just to avoid it. And that literally means that they will sell a property that they know that they have failed to respond on to people and not tell them about the liens that are outstanding on it. And while I do hold investors and stuff accountable for their own due diligence, it's just amazing to me that they will shuffle them off as quickly as possible. So.
Couple of things I'd like to ask you. Is there an app? Does the city have an app where our constituents can report a vacant building?
Yes, they can.
So are we doing a lot to promote that and
yes,
get the word out?
And on Nextdoor, I periodically put out flyers and stuff about the importance of them notifying us when there's squatters in the neighborhoods, and it doesn't matter which neighborhood it's in. It's important in any neighborhood because the sooner we can get there and assess the property, see if it's got power or not, the sooner we can get something done. In fact, we've utilized the city attorney's office this last year numerous times, probably at least 10 that I think of right off the top of my head, to where we've issued a vacate and the people will not leave. There's no power or water, and we have to go get a court order to go ahead and put them out of the building and then have a contractor secure it up right behind them as they go. So it's been, processes are doing very well, and we're being very successful with it.
Okay. Thank you. Thank you. Any questions, Councilman? Nope.
Okay, I move for approval then, Your Honor.
Okay. Of course, public hearing on this item. Anyone wishing to come forward and address this agenda item 201718? Close public hearing. And by the way, each bill moved out of committee today will be eligible for adoption at the City Council meeting on June 21st, 2017. There's a motion. Yes, sir.
One more up. I've been killed. Can I use your
Now you're back.
Here we
on.
go. Okay. This bill has a section 6 has a sunset clause in it that was tied to the state legislation that also sunsetted this year. The legislature has passed a bill to extend that another 4 years, so we would recommend that section 6, which now has a sunset date of June 30th, 2017, be changed in a First Amendment to June 30th, 2021, so that will coincide with the new state legislation. Recommend it be passed as a First Amendment.
Okay, yes, I'll modify my motion, Your Honor.
Okay.
Thank you, Already.
In
I
favor, please.
move for approval of this bill with an amendment that would be in section 6, change the date to June 30, 2021, and that would be move on the First Amendment.
Okay. Motion, all in favor, please signify by aye.
Aye.
Okay, the motion carries. Thank you. And that's 2021. Okay. We'll move on to bill number 201719, possible action amendments to municipal code to add provisions requiring the installation of the automatic sprinkler system in all new residential occupancy, sponsors by Councilman Steve Ross.
Good morning, committee. My name is Thomas Marimonis. I'm the acting director for Las Vegas Fire and Rescue. I'm here. Chief McDonald is on vacation today. We're here to talk about the bill and answer any questions that you may have. So let me, I'm going to introduce our Fire Marshal, Chief Nolan, and he's going to do a small presentation.
Good morning.
Thank you, committee members. What this bill is about, 2017-19 amends Title 16 of the Municipal Code to provide for automatic fire sprinkler systems to be installed in all new 1- and 2-family dwellings built in the city. Las Vegas has been called one of the safest resort districts in the world. We'd like to see that same level of safety provided to our citizens. Sprinklers have been installed in commercial buildings in the city of Las Vegas for a number of years. New apartment buildings, townhomes, and motels have been required to be sprinklered since 2009, and since 2006, 10,000 square foot homes, and in 2009, 3-story homes have also been required to be sprinklered. So what we're trying to do with this bill is to close the gaps and capture those production homes of 1 and 2 family dwellings. As required by NRS 278.586, an independent cost-benefit analysis was performed by UNLV School of Public Policy, right here, and there will be a associated public hearing on the results of this analysis tentatively scheduled for council on June 21st, 17. While it is a separate item from this bill, it's my understanding that the bills will be trailed so that you can discuss them both conjointly at that time. If this bill is not approved, no sprinkler ordinance would be put into place. Most homes built in Las Vegas would be continued to be built without any benefit of fire protection other than smoke alarms. Our fire response times currently average 6 to 9 minutes. Modern homes built with synthetic materials and plastics burn up to 8 times faster, according to Underwriters Laboratory, than homes built 20 years previously, and they produce very toxic black smoke. Escape time can be as little as 2 to 3 minutes, as compared to our response time of 6 to 9 minutes. Modern home construction materials and methods include many types of manufactured, pre-engineered, lightweight products, trusses built of plywood webbing, 2x4s and nail plates. They're cheaper, they're lighter, they span greater distances. They're fine products from an engineering standpoint, but under the duress of a fire situation, combined with no fire sprinklers, they create the perfect storm for both the occupants and the first responders. If this bill passes, the enactment date would be at least 6 months in the future to allow for contractors to prepare, or it could be made to coincide with our city's next code adoption cycle, proposed for the 2018 codes. That would simplify implementation for all of our partners. Industry notices, meetings, and workshops will continue to be held to inform and prepare the affected businesses. A business impact study and meetings have already been conducted prior to this bill. The stakeholders regarding this bill are contractors, home builders groups, fire sprinkler contractors, and other construction trades, organized labor such as IAFF, the developers, the development community, and the Las Vegas Valley Municipal Water District. We've had discussions with them throughout our 2-year process of bringing this bill before you. That concludes my report on the subject.
Thank you, Chief.
One area Chief McDonald's been talking about is that the impact and why is the fire deaths within our community. So within the last 11 and a half years, our data shows that 51% of the deaths within our city have occurred in single-family homes. And so that's why the emphasis and why the fire chief and why we're moving this bill forward.
Thank you very much. This is, yes, please, Councilman.
Okay, I'm a little confused because you have this cost-benefit analysis that's scheduled for June 21st. So how would I vote on this today if I don't have the cost-benefit analysis? I'm kind of wondering why this is even here today. And you say you still have business impacts and workshops and stuff. So it's, I mean, I can't vote on this without the cost-benefit analysis.
We have concluded our cost-benefit analysis in December of 2016, and we made it available to the stakeholders through outreach in the community. It is required to be received at a public hearing in front of the council members, the policymakers of our board, and that we're trying to do that at a meeting conjoined with our bill.
So today is the public hearing at the recommending committee. So has that been introduced here today?
They could do it.
Do you have that today, the cost-benefit analysis?
Yes.
By UNLV?
Yes, I do have a copy of it.
Okay, isn't that why we have
well,
recommending?
As the chief points out, that's a public hearing that NRS requires to be listened to, and the council needs to make certain findings before you adopt the bill. If you don't want to move the bill along today, you can vote against moving it along. I think the idea was move the bill along, reserve the right to vote against it if you want when it comes up for adoption, and if you want to make your decision based on that cost-benefit analysis, you can certainly do that, on the 21st. Like I say, if you don't want to do that, you can certainly vote against moving it forward today. But it was an option that we wanted to be presented to you.
Is this available to the public, the recommendation of UNLV's group? Is that available to the public now?
Yes, it is available now. and
It's
I believe-
online?
Is it online? I believe it was online as part of our business impact study that we conducted.
So are you done with the business impact study?
That's correct. We have concluded the business impact and filed that.
So where, I guess, where is all that? I mean, if I'm supposed to vote on it today,
Councilman, you approved the business impact statement when it was introduced,
Right.
just like you do all. The business impact statement just reports what was done. It reported that there was a solicitation, and it reported that I believe one response was received.
okay.
Okay, let me hear
Mayor?
from the public. Do you want to
Okay.
make your
Well, I just
comment
wanted to-
first?
You know, I don't know why you didn't prepare it for us today, but I understand how the process works. I think it's important to know that if that's been completed for 6 months, I haven't received one complaint from anybody.
Throughout the business impact study, throughout the business impact solicitation, there was only one complaint, and it was from the Southern Nevada Home Builders Association, and they filed that, and that was read into the record. And it was over the preparation of the cost-benefit analysis. They sound similar, but they are two different documents. The cost-benefit analysis performed by UNLV has been made available to our stakeholders throughout the process once it was completed in December of 16, and then we conducted the business impact outreach with all the stakeholders.
Okay,
Well, I
let me
mean,
hear
they
from the
may have sent a
public.
letter, but 6 months ago, I haven't heard from anybody in the Home Builders Association. They've all been here on
They'll pass
other
it on
stuff,
to
but
the
never on
buyer
this.
anyway.
Mayor, City Council, we've been meeting with Matt Walker from the Home
And
Builders.
who are you, sir?
I'm sorry, Orlando Sanchez, Deputy City Manager. We've been meeting with the Matt Walker from the Home Builders Association. We continue that meeting, and we are doing some updating to the study based on our conversations where he had questions on. I know Deputy Chief Nolan is currently working on trying to amend the contract with UNLV and make the recommendations or some of the changes that they had concerns with.
Thank you.
Is that correct, Mr. Nolan?
Thank you.
That's correct. A lot of it has to do with editing into the report other work that was done in conjunction with the cost-benefit analysis to be more explanatory and to inform their conclusions in the form of, we anticipate that would be in the form of an additional appendice to the report, but not significantly changing the findings.
Okay, let me hear from the public now. Public comment. Anyone wishing to be heard on agenda item 201719? I'll close the public comment. Do you want to make a motion on
I'll
that?
go ahead and move it, Your Honor, and the reason
Move it
is
forward.
because or at least, there still can be comments on the motion. I'm going to move for approval, having not heard of any amendments to be brought forward today.
Okay.
And the reason is because, number one, if the home builders filed an objection 6 months ago, they probably are still opposed, and they're discussing with you, but they're not discussing with us, which is, the one where they should be talking, and so they probably will be opposed. But they are always opposed to fire sprinkler bills. That is just a given with them. The fire sprinkler agreements that were entered into, I don't know, 4 or 5 years ago, they have expired, or at least they should have expired, because it virtually left the individual home buyer naked without this when it could have been done. So that's why I'm going to move for approval on it today.
Okay, in favor, please signify by aye.
I'll support the motion, but I'm more moving it along to the city council, so I reserve judgment based on reading everything else. So just
But
put that
okay
on the
to
record.
move it forward.
Yeah, I'm fine moving it along.
Thank you very much. That motion carries.
Thank you.
Thank you, gentlemen.
Hey,
Now we come to agenda item 5, which I don't understand at all, and I hope you're both coming back. Bill number 2017-20 for possible action that amends the supplemental document pertaining to the city's fire code to remove the automatic sprinkler requirement that specifically pertains to buildings exceeding 10,000 square feet in size or 2 stories in height. This has been sponsored by Councilman Bob Beers. So If you'll reintroduce yourselves for the record and...
Thomas Marimanas, Acting Director, Las Vegas Fire and Rescue. This is not our bill from Las Vegas Fire and Rescue, and so we are opposed to moving this bill forward.
Okay, I mean, to me, you're just on opposite sides of the coin with both of these. Do you have comment on this, or Mr. Seed?
All I can say is that the city manager felt like because these are both about sprinklers, that they should be heard at the same time, understanding that one comes from a pro-sprinkler direction and the other from a against sprinkler direction. And like the chief says, it's not really their bill, but it's something that someone asked Councilman Beers to bring forward.
And he'll have an opportunity at council. Councilman Coffin, any comment there?
Well, I can't support this if,
I
in fact,
can't
it runs exactly contrary to the first one. Maybe there's some technical reason why this language would be removed from the current ordinance. That
So this
make it
would just go
compatible.
forward then to council with negative votes then, correct?
Well, I'm not going to, oh, yeah.
Yeah.
Yeah, we could do that.
But this is public hearing. Anyone wishing to address this particular agenda item? Okay, close public hearing on that. And your motion will be?
To deny, well, I say to move forward with a negative recommendation.
Same recommendation, negative, and mine's the same. So it will carry the three of us negative against this. Thank you.
Thank you.
Thank you, Chief. Okay, agenda item, okay, Councilman Anthony, I am on, because I have a son who's in the medical marijuana business, I cannot address this. If you would read 6 and 7 and take those, the two of you together. I will abstain.
Okay. Val, should I do these together or separately?
Can I speak on them?
Together or
Yeah.
separately? Okay. All right, so agenda item number 6, bill number 2017-21 for possible action revises and broadens the current zoning regulations pertaining to medical marijuana cultivation facilities, dispensaries, and production facilities to include similar facilities engaged in retail operations pursuant to NRS Chapter 453D. Sponsored by Councilman Coffin. Staff?
If
Good
I could
morning,
just say
Peter
something
Lowenstein,
first.
Planning Section
briefly.
Manager.
Sure.
I just want to make sure that it's understood. I did request these bills. I did it by request because the legal wanted to have and the department wanted to have a sponsor, and it seems to contain all we want. But now I have to make sure that after you present this, that in fact it does. So that'll be up to you and the witnesses. I hope so. Enough people are here to witness on this. Thank you. Thanks, Mayor. Thank you, Chair.
Go ahead.
Once again, Peter Lowenstein, Planning Section Manager. This bill seeks to amend the zoning ordinance to provide revised definitions for marijuana uses that will proactively address the approval of Question 2 in the Nevada general elections back in 2016, which legalized the recreational use of marijuana and its subsequent codification in NRS 453D. This amendment seeks to accomplish the following. Creates one land use category for marijuana cultivation facilities, marijuana dispensaries, and marijuana production facilities. Revise the description of the uses to include both medical and retail from NRS 453A and 453D, respectively. Revises the minimum distance separation requirements to be in conformance with Nevada revised statutes by requiring the following: 1,000-foot separation from any school, 300 feet from any city park, church, community recreation facility, public, individual care family home, individual care group home, individual care center licensed for the care of children, commercial recreational amusement indoor, as well as commercial recreational amusement outdoor, library, art gallery, or museum, public, teen dance center, martial arts studio that provides instruction to minors, general personal services that provide significant portion of its services to minors, and any other use whose primary function is to provide recreational opportunities to minors. And as well as it eliminates the Downtown Design Review Committee review of building elevation and signage for dispensaries. That is how it was introduced. Staff is proposing a first amendment to this bill, as the original bill has the potential of being too restrictive distance separation requirements as it relates to NRS. The proposed First Amendment does the following. It amends the distance separation to still maintain the 1,000-foot separation from any school. The 300-foot separation would be from a city park, church, individual care family home, individual care group home, or individual care center licensed for the care of children. A community recreational facility public, as well as any use whose primary function is to provide recreational opportunities to minors, including indoor or outdoor commercial recreation amusement uses, libraries, art galleries or museums, team dance centers, martial arts studios that provide instruction to minors. As well as the amendment also applies distance limitations in effect at the time of the approval of the existing special use permit for medical marijuana establishments that were established prior to July 1st, 2017, as well as treats those uses as conforming uses going forward.
Yeah, so, let's try that one more time, a little simpler. So just give me what are we trying to do here? We're trying to change the zoning for what?
All right, so as introduced is to...
How is it today, and what happens if this passes?
So today, the zoning code only applies to medical marijuana. This would introduce the retail element that was approved by Question 2 in 2016.
Okay. All right, very good. Anybody else, any other city employees want to speak on this? Okay, Val?
Yes, I just wanted to point out that each of you has a copy of the proposed First Amendment that Peter was just referring to do that additional cleanup. And also there are some copies down at the front that are available to the public if anyone is interested.
Okay, this is public comment time. Anybody from the public wanting to speak on this? Come on down here.
Good morning. My name is Bob Gronauer, 1980 Festival Plaza Drive. I'm here representing Brian Paget with CW and also John Ritter with TGIG. We appreciate staff and working with them with respect to the First Amendment. We're in support of it and appreciate all the hard work that they've done to get us to this point. So I don't have anything else to add, but just say thank you to your staff, and we're in support.
Anybody else? Okay, close the public comment. Councilman Coffin?
Thank you. So we will move to pass the First Amendment, and I believe what it does do, something you didn't mention, is that we don't call regular marijuana sales recreational. In our ordinance, it is termed retail, and I think that matches the state statute, doesn't it?
Yes, that's correct. We reference it as retail marijuana.
I'm sorry, I should have said your name for the record. And the reason is because it doesn't make sense to call it recreational. It's going to be medical and, general use, but it's, in a sense, we're regulating it like alcohol, same sorts of exemptions, same sort of restrictions, and it accomplishes the same thing for the user, intoxication. So we don't want to just say, we don't call alcohol recreational alcohol, it's just alcohol. But because there has to be a difference between types of marijuana sales, we say retail for this and medical for the other. And then I think eventually we're going to merge them together. In fact, that might be the next bill. Am I correct?
The next bill is for the licensing, for merging it together,
All
yes.
right, well, I think that's why we needed to do this. It's a practical bill. I move for approval. First Amendment, excuse me.
Okay, motion to approve with First Amendment. All's in favor?
Aye.
Aye, opposed,
And I
motion carries unanimously.
And I abstain.
And the mayor abstains. All right. Item number 7, bill number 2017-22 for possible action authorizes the issuance of limited duration licenses by which holders of medical marijuana establishment licenses may operate as dual-use marijuana businesses under NRS Chapter 453A medical marijuana and 453D retail marijuana, sponsored by Councilman Coffin. Go right ahead. Aye.
And again, I requested this, Mr. Chairman, thank you.
Okay.
By request of the industry and staff, because staff wants to have some guidance as to how we handle these folks that have, and are soon going to have 2 licenses. Thank you.
For the record, Mary McElhone, Business Licensing Manager. So what this bill does is it creates a dual-use license that authorizes the issuance of a limited duration license. It allows holders of a current medical marijuana establishment license to also operate a retail marijuana business. And in order to obtain this dual-use license, the holder of a medical marijuana license must meet certain criteria. First, they must possess a valid state-issued medical marijuana establishment registration certificate and be operating in good standing with the state of Nevada. They need to possess a valid state-issued temporary license to operate a retail marijuana establishment. They must also possess a valid city medical marijuana establishment license and be in good compliance with the City of Las Vegas. And they must have opened and be operating with a valid city medical marijuana license and state license as of May 31st, 2017. So this dual-use license is going to expire on April 1st of 2018. It is only temporary. The Department of Taxation temporary regulations are only valid for 90 days after January 1st of 2018. So they do plan on coming out with more permanent regulations. They were waiting until the legislative session was closed, and we will be coming before you again sometime, hopefully this fall, with also a new draft of retail marijuana licenses. So the fees are not going to change. They're going to be the exact same fees and the current fee structure that we currently have for medical marijuana. We did a recent amendment to the medical marijuana annual fee of $75,000. We changed that. We made that an origination fee. So what we're doing here is that anyone who has paid that flat annual fee between July 1st of 2016 and July 1st of 2017, that's going to be credited towards the origination fee for this dual license. So almost everybody is not going to have to pay an origination fee. This ordinance is going to expire on April 25th, 2018. We just have this as a temporary nature ordinance to keep in track with the state licenses with their Early Start program. Thank you.
Thank you. All right, this is a public comment time. Anybody from the public wishing to comment? Okay, I'll close that. Councilman Coffin.
Well, thank you. I want to make sure that we have something cleared up, and that is that we'll have, because we've got situations where people have moved in with other businesses, it might have previously been prohibited or would have caused a marijuana license to be prohibited in the case of medical. So we went through all of that. We permitted those we could, understanding that there were, in some cases, waivers needed, but in most cases not. So now then, as we pass this, does this affect, does it hurt anybody negatively who has a medical marijuana license that wants to have a dual license?
Between the land use bill that was just spoken about and this one, what it does allow effectively is anyone who currently holds a medical marijuana dispensary license, they will be able to sell retail. So it doesn't have a negative impact. It should be an easy process. Okay. And all those special use permits will have a review of condition. Those will be brought before you on the June 21st City Council.
Then one last question. So nobody's losing any rights anyway at this point. And,
at this point in time, nobody's losing any rights. It should be an easy and smooth transition for them.
And no surveys need to be done because?
Everything that we've requested has been turned in, so there's no new surveys that they'll need to turn in.
Okay. All right, thank you very much. Then is this movable as is, or does it need any amendment? Val, did we get another bill printed? I didn't see the other one earlier.
No, this one's okay to move as is.
Okay, move for due pass on bill number 2017-22.
All those in favor? Aye.
Abstain.
Mayor abstains. Thank you very much. It's all yours, Mayor.
Thank you very much. Citizen participation, public comment during this portion of the agenda must be limited to matters within the jurisdiction of the committee. No subject may be acted upon by the committee unless the subject is on the agenda and scheduled for action. If you wish to be heard, please come forward, give your name for the record. The amount of time or on any subject will be limited. Hearing and seeing none, I will close the public comment and move for adjournment.